Welcome to The Aftermath, a podcast that rips the Band-Aid off the collective scars of divorce, custody battles, and the trauma of family drama. Kendra Reiber and Mick Smith pull back the curtain and explore stories that put the heart-wrenching puzzle pieces together with inspiring stories, notable experts, and actionable tips. Let the healing begin. Oh, welcome once again to The Aftermath. Oh, Kendra, how are you doing today?
I'm absolutely wonderful, Mick. I'm looking so forward to this episode. I know this is one that a lot of people struggle with as far as obtaining legal counsel. And so I'm so excited to get into this and dig in.
And I have been looking forward to this for so long as well. So me as well. So hope you're doing great. I'm looking forward to it, and everybody listening too. Let me introduce our two guests because we got an attorney panel today. We have two special guests. We appreciate their time and taking some time out of their busy schedule to be with us. We have Richard A. Julius. Richard A. Julius is a senior litigation attorney or partner. He is in Pennsylvania, a state that I know and love very much. He helps people daily. He has clients, keeps them up to date, and attention to detail. He looks at the process as not winners and losers, but it keeps a family interest in mind. He is intelligently aggressive. He informs people that he's working with so that they know their options, somewhat predictable, and then to help them to understand the effects of each option and the consequences of inaction and make an informed decision. So that is Richard's senior litigation partner. And then we also have Marcy Patton Kaufman. She also is a senior litigation partner. She is in Ohio, a state that Kendra knows well. She has a passion for family law. She's known for her thorough understanding of the law, the ability to communicate effectively with clients, qualities that make her a successful family law attorney. Also, very interesting that she had won temporary custody for a father that eventually resulted in full custody. So we had questions for these folks and can't wait to hear what they have to say. How do you get an attorney? How do you engage them? How are protection orders used in custody situations? How can an attorney intervene when someone takes off with the child or children? And how are court orders enforced? And these are things that we would really like to hear about and hear answers. So with that as an introduction, we have both Richard Rick goes by and Marcy. Welcome to the program. Thank you so much for taking some time out and chatting with us today.
Thank you for having us.
Thank you, guys.
So why don't we start maybe with the first question that we had said. So it's a open question that we would really like to hear about because some of us have had some difficulties with attorneys, and the people that we've had numerous attorneys. So one of the things that we would like to really get an answer to is how and what's the firm's process of an engaging attorney that will really be helpful for a potential client? How can you help us out?
Marcy, you want that one?
Sure. Well, I think when it comes to, obviously, Cordell has its own, process for retaining counsel and, meeting with an initial consulting attorney who then assigns you an attorney that is, best fit for you. But in switching the roles, I think when a person is looking for counsel and, they're trying to determine who that person is that is going to assist them and provide them the most benefit in their divorce, they really need to look for someone that feels right to them, because it's got to be somebody that they can trust, that they can communicate with, that they really feel is going to support them and is going to fight for them and help them reach their goals. So having that, I don't want to call it kind of a bond, because it's a working relationship. It should be a partnership. It should feel like a partnership with the easy flow and exchange of communication. And from my experience, as a divorce attorney, I find that different people need different things. Some people need an attorney that has plays more of the therapist role, and helps them through that process. Some people need an attorney that's more of a more stern hand, that provides that guidance that helps them, through that process. And some people just need, that partner that we can work together, that we can strategize together. It really does depend on the person and what they need, from my personal experience and opinion. Rick, do you have anything to add to that?
Yeah, I think those are great points. Just to kind of piggyback off of that, I always encourage people interview more than one attorney. I'm happy. I stand by my pitch, my advice, my anything that I'm telling a client in my initial consultations. And if they have other consultations set up with other law firms, with other attorneys, I encourage that. I said, get it scheduled, get it done. And I'm confident that they'll come back to us on that, but they have to find somebody that they're comfortable with. And a lot of times we get folks that have been with other attorneys who didn't quite realize what they were getting themselves into because they just knew they were an attorney. And all attorneys aren't, built the same. They're especially in such a nuanced area of law. Some of them will be like, well, I have a friend who practices 12 different areas of law, and they said they can help me on the cheap. Well, I usually tell them, think of it as a construction worker. I'd rather build on an empty plot than to tear some other guy's, less than desirable structure down and have to do it all over again. So you have to be cognizant, you have to be communicative with what your goals are, and you have to, like Marcy said, get the right vibe that your attorney is somebody that can really further that agenda and understands that agenda probably more than anything.
So if I can follow up on this, I'll say this is definitely hindsight, because I was in the state of Pennsylvania and I was trying to think strategically, right? So I had two attorneys. One was a person who considered himself a father's rights attorney, and that didn't work out well. So then I said, well, in a lot of my ways, in my situation, my living environment was more like a woman and had a very successful locally feminist attorney. So I said, all right, I'm going to try her. Well, anyway, neither one worked. So I said, by hindsight, in Pennsylvania law, is there anything that you could say that what was wrong there, what went astray, what could I have done that I probably improved myself, my situation?
Well, it certainly sounds like you kind of took an approach that maybe it was a bigger cause than just your own, when you should have taken to this being your case, your life, your kids. The grander battle, if it's fought, should always be secondary to what's important to you. So it probably wasn't the best decision to say, I need somebody that specializes in my role in this greater cause, or my perspective in this greater cause. I need somebody that understands where I'm coming from, my roles, my family's roles in all of this, so that they can best navigate the strategy for me.
Yeah, and to kind of think, like, to double up on that, it's a matter of mindset. Like you had said before about Rick indicating that it's not winning or losing. You almost need to look at it as it's an investment in your future. Right? Because you're closing one door and you're opening another, and you want to make sure that when you open that other door, you can move forward as smoothly as possible. So trying to approach it with the correct mindset on moving forward, I think also helps and assists you in obtaining the right counsel for you.
Yeah, I think divorce and custody are hard enough alone, let alone the idea of shouldering some, greater cause, greater burden, of someone else or some other group of people on your backs. It just needs to be something that works out for you, and then hopefully spreads to other people by getting you the good results that you need, not furthering some cause.
I think that's great feedback. Several takeaways that I had from that is we want to interview a few. Rick said we want to maybe figure out which person bonds with us best, Marcy said. So whether it's we need a therapist or we need somebody with a firm hand. And, just to follow that up is think about yourself, because I think that's something that we kind of lose. At least in my situation, I was thinking about the children, and I didn't think about my future. And that was something that I can learn from.
Yeah, I always think about the warnings on an airplane before you take off. It's like, put your mask on first before you help others, and make sure that you're taken care of. Especially in roles when there's custody there. If you're not taking care of yourself, you're not going to be in a good position to be able to take care of your kids, and that is especially true in litigation. So,
yeah,
definitely.
Yeah. Well, great. Well, let's move on to the next question. How are protection orders used in a custody case? And the reason that Mick and I asked this question is because Joe had brought up to us that protection orders can be used as weapons. And maybe we're asking you guys to elaborate a little bit further on that, because protection orders seem to be so commonly used in custody cases. So what do you see and how do you approach that as an attorney? I guess depending on either what side it's on, right? For your client or, against your client or your client's using that, I guess.
I think that it's first really important to acknowledge that protection orders are necessary. There are certain situations in which they're 100% necessary, and they're a necessary tool that people need. Now, unfortunately, there are circumstances when they get used, to get one up on a custody case or, whatever, to manipulate the situation. And that makes our jobs twice as hard, because there's never going to be, when you think of the judiciary, you think of judges, you think of magistrates, those that are making the decision. None of them want to be the person that got it wrong, right? None of them want to be the person that says, you know what, I'm not going to issue a temporary protection order or a domestic violence civil protection order because this case is too weak. And then have something come back, some horrible event come back, 2 weeks later, 3 weeks later, and they find out they're wrong. They're always tend, for the most part anyway, to err on the side of caution. But that often opens up a chance or an opportunity for people to manipulate and to use them inappropriately, to get up on custody, to get somebody kicked out of the house, to, I hate to say manipulate the system, but I don't have another word for it, so to speak. Mm-hmm. But when that happens, it makes everything twice as hard, because now the parties can't communicate because there's a protection order in place saying that there's no contact. Often parties can't see their kids, even if their kids aren't a part of the protection order, and it's just a spouse that has been protected by them. But that spouse also has the children in their possession, and since they can't be within so many feet of that spouse, 100 feet of that spouse, whatever the circumstances may be, now they can't see their kids either. And often it takes a long amount of time to remedy these things. So one parent may end up going a significant amount of time without seeing their kids. And that can just almost start a whole domino effect, because you're dealing with a domestic violence civil protection order case that's now going to go into your divorce action, which is going to impact your parenting time and your temporary parenting time orders under that divorce action. I thought I'd give you a chance to talk, Rick.
No, it's all good. No, I really think that particularly in the post-COVID era, we're seeing a lot of that sort of weaponization of protective orders. I think we're in the middle of a societal kind of course correct to the idea of domestic violence, and with the social justice campaigns and that sort of thing, we're starting to see a lot more legislation to actually make PFAs, as they call them in Pennsylvania, more powerful. So, just to kind of expound on what that looks like in Pennsylvania, is all it takes is an allegation that rises to the level and a light most favorable to the party claiming abuse to get a temporary order. That happens at a hearing that's what they call ex parte. It's the other side's not even invited. You could know about it. You could be sitting in the hallway of the courthouse and you won't even be invited into the room to defend yourself in that hearing. So you're effectively, if the person alleging the abuse even rises to that very small standard, they're going to have you kicked out of the house and probably not seeing your kids for roughly 2 weeks at a minimum. And then you end up at what we call a cattle call for final hearings, where there might be 50 hearings scheduled all at the same day at the same time. And you're hoping to get enough time to be able to talk a judge into hearing a case in its entirety in order to defend your client and all of that. There's so much at stake in all of that now what we're seeing is it's becoming even more weaponized in the backlogs that exist in the court post-COVID. It's, if we file a custody action now, we know that there's a pretty good likelihood that we're not going to see a custody trial inside of a year. And so whatever is going on until that custody trial is going to control a huge part of those kids' lives, a huge part of those parties' lives. And so people are feeling tempted to, dare I say, abuse the abuse system and bring these claims that might be exaggerated, bring these claims that might just be patently false, because the alternative is this untenable situation where they feel as if they can't get into court for an extended period of time. And we have backlogs that are even longer than those ones are. So when we talk about how it's sort of weaponized, it's weaponized because we've created this system that allows it to be weaponized. And we're actually, in Pennsylvania, there's legislation pending to try and further weaponize it to the point of wanting to add house arrest as a provision for what is a civil order. These are civil protection orders. You don't have a right to counsel. You don't have Miranda rights. You don't have any basic criminal rights, habeas corpus or otherwise, unless and until it's violated. So at that point in time, you're utterly defenseless, but you're also subject to criminal law as a part of it. A lot of people don't understand that when they're on the defensive side of things. Most counties in Pennsylvania have mechanisms in place where plaintiffs get free counsel and have zero mechanism for defendants to have counsel. So we start to see things, economic inequities, where one party gets a free attorney, the other party can't hire an attorney, but needs an attorney, or otherwise they're making decisions that are impacting their family when they're literally up against a wall. So from the weaponization standpoint, I absolutely think that it's a problem out there. I don't know what the fix to it is. I caution my clients against it every time I meet with them to try to stay out of it and play defense and make sure that they're not subject to it. But it happens every day. And, not to discount the fact that it's there for a purpose. But what I'm seeing is there seem to be a lot more that don't have that purpose of true protection and are more a litigation strategy.
That is so very sad. Thank you both for sharing. I have been subject to the protection order filed and then not seeing the kids or having any contact for 7 months, which led to the ultimate decision from the GAL that I didn't have a good enough relationship to have full custody. So I am in that position. Typically, I know you guys represent men. Typically, that's happened to a lot of the men. We are now seeing happen to women across the board as well. So it is being used on both sides. And unfortunately, we've gotten away from actually using the protection orders the way they need to be used in those situations, Marcy, where they actually are needed, right? Yeah. Now it's just another piece in the chess game. And that's very sad.
And it is, it's incredibly sad, and it's a snowball, because you're essentially setting a standard, right? You're setting okay, this parent can't see the kids. And if it goes on for that long, 3 months, 6 months, it completely changes the dynamic. So now we're also probably facing additional costs. We're probably facing some kind of reunification therapy, counseling, maybe supervised visitation that you have to pay for somebody else if you don't have a center available, which individual supervised visitation is much more expensive than a center, but either way you have to pay for it. So it's a snowball effect. But even if you are cleared on every single thing, it still impacts the whole parenting dynamic, because the courts are still going to base it on the best interest of the children. And if over that 6 month period, the children are now concerned or scared or whatever, this court's still going to hesitate to, have unsupervised parenting time or overnights or whatever, because they want to make sure the children are comfortable, despite it not being the other parent's fault, despite the parent not doing anything. It's just the circumstances. And at the end of the day, the court is always going to look at what is best for the particular children involved.
Correct. Yes, I agree 100%. And to expand on that, you now have a psychological problem with the children because of that time period. Like you said, they might now be scared where they weren't before. Now, all of a sudden it's like, oh, wait a second. I haven't seen mom or dad in 6 or 7 or 9 months. And, I've been told all these things. And so now I think I'm afraid of my parent when I wasn't before, but I think I might be. And you make them doubt. And so if you don't have the right counselor or therapist or whatever might be working with the kids that are recognizing these issues, you have an even larger problem that the courts will never be able to solve.
And that's its own backlog too, Kendra, because it's so difficult to get appointments, especially with folks who aren't already installed with mental health treatment in their lives. You can't get an appointment at a lot of folks, especially if they know that there's a custody litigation involved, or it might, consume more time, where they might be, taking up the space of two patients with your one case, where they're backing it up months and months to get even an initial appointment to try to start remedying those situations. And then it just kind of works in that snowball effect, like Marcy said, that the delay has caused this issue. And then it doesn't matter why they're afraid. It matters that they're afraid. And the further that draws out, then the more afraid they're going to get. And so it just keeps perpetuating itself.
Yeah. And Rick, I wanted to come back and touch on something you had said, and I'm very surprised that Pennsylvania is going the opposite way than surrounding states, which is Kentucky and Arkansas. And right now, Ohio is looking to propose and pass a bill that would be, they need clear and concise evidence, clear and convincing evidence versus a preponderance of evidence. So when they file these protection orders and it goes through, they have to have clear and convincing evidence, not just a preponderance. And there's recourse for false allegations. So
I've never once seen a punishment for false allegations, and I've litigated a lot of these, and I understand why. And I've heard the words chilling effect, or we don't want to dissuade folks from coming forward, and that sort of thing, as a reason to say we're not going to punish this person in front of us, even though we've basically proven that they've lied or misstated things in their petition, because we don't want somebody who really is being abused, to refrain from coming forward. But right now, I think that's part of the reason why it's gotten out of hand, in that there is this, the worst punishment for getting caught with your hand in the cookie jar is that you're going to have to put the cookie back. Mm-hmm. And if that's the case, then why wouldn't these folks try this?
Mm-hmm. Yeah, I think when you have the law changed that you have to have clear and convincing evidence, then it is a little harder for somebody to come forward with false allegations. So they're not going to be as apt to do it. And so we're actually going to get to those serious cases where there is child abuse or domestic abuse that needs addressed. And when you look into Kentucky, they have about a 50% reduction in those false allegations that were presented in custody cases. They're not in court all the time fighting these. So you're actually getting the real cases. And I think that is where Kentucky has excelled. Sweden also has a 50-50 shared parenting that works really well for them from the time that they separate. So they don't have anybody in court kind of fighting these battles out. Or attorneys like you can actually go in and work on the real cases that do need work. Right. So, and get to the bottom of it in a shorter amount of time, hopefully, like you're saying, Rick, the backlog.
Well, I wanted to shift gears here a little bit too. It was a very interesting discussion. We have had a number of people, and again, some of us can relate firsthand. What can an attorney, and by reference to that, the court, intervene when the absconding parent has taken a child or children? And this is when the situation happens where the person just picks up and takes off. They go to another city, they go to another county, they go to another state. And there are also those people who just say, I'm leaving the country. So what can an attorney or the courts do when all of a sudden, or one party, the parent just takes off with the child? What kind of steps can be taken, and can anything be done to stop an absconding parent from taking the child or children?
You want me to handle this one, Morris? We're kind of blessed. At Cordell & Cordell, we have offices all over the country. So, the short kind of snarky answer is we pick up the phone and call one of our colleagues in whatever state that they were in when they absconded. But I think the fact of the matter with this is there's not a lot that an attorney can do to play defense. I think it's one of these best defense is a good offense approach is to say, what are we anticipating to be the problem? Do we anticipate issues with contempt or violation of relocation statutes and that sort of thing, to say that whatever that order ends up being has the necessary provisions to enforce that order regardless of where that child may be. And it's an often overlooked portion of things, especially when people are coming to agreements on things, to say, well, we're agreeing to it, so there's not going to be these enforcement issues, so we don't need to supply the teeth to the whole thing. But having lines in there that allows for the deputization of law enforcement wherever a child may be to enforce the order, language that requires communication of travel prior to, so that there isn't an issue where a child's gone and the parent thinks they're on vacation. Having those enforcement mechanisms already built in and having an understanding of what it would take to have them enforced in a different jurisdiction, I think is paramount to that intervention, because otherwise you're basically playing a catch-up game of bringing to the court's attention that somebody's violated it and then hoping that the court gives you the appropriate remedy after the fact, and realistically probably spending thousands of dollars in the process of having it enforced.
There are processes, and I don't, these take time. So if you're in a situation where you don't have any court orders, right? There hasn't been any parenting time orders issued. Nobody's filed for divorce, but just somebody up and leaves. There are processes and things that you can do to attempt to get a child returned to you. But again, they take time. You still have to go through the motion of filing the appropriate actions with the court. You still have to know where that other parent took the child. You have to get in contact with that court. You have to register that order. You have to get that court to order the return to the child. I mean, it is a process, and it can be done. We've done it. My office has done it. We've had a child returned from Canada, but I'm not going to say that it doesn't take time, because it does. It takes a significant amount of time. And to touch on some of the things that Rick was saying, you can issue orders. If you have a parent, or one party is concerned that the other party is going to flee the country with the child, you can put things in your parenting time orders to make that more difficult. You can put provisions in there that says, whatever parent is to keep the passport. You can put flags on the passport. You can make a parent pay a bond if they want to travel out of the country, meaning that a third party is going to hold a certain sum of money, in place until that parent returns. You can put limits on where they can travel. Via a decree. You can say they can only travel to countries that are part of the Hague Convention. They can't even travel through countries that are not a part of the Hague Convention. And what the Hague Convention is, for people that maybe aren't familiar with it, it's areas of the different countries that have signed the Hague Convention Treaty, and that essentially says that they are going to enforce custody orders of other countries and assist in getting those children back to their country of origin. But again, I don't want anybody to think these are easy processes, because if you have to go through a Hague Convention process, you're probably looking at years before you can get your child back. They just take time. And if your child ends up in a country where they have not signed a Hague, they aren't signers of the Hague Convention, then that country is not going to enforce the orders of that foreign court. So there are processes. It's necessary for people to know that they do take time, and that time in itself is going to have its own consequences.
And I think this doubles back to something I had said earlier about just having the right attorney and having somebody that specializes in the problems that are at hand for you. These are nuanced areas of the law that not everybody is going to know, because even us as folks that do nothing but this for a living, we only handle a couple of these to a few of these a year, let alone somebody that doesn't even necessarily know that area of the law, doesn't know UCC JEA laws and how they apply in different states, doesn't know about the Hague Convention or what countries are signed to it. And it goes back to that idea of defense and not allowing this to happen in the first place. Because like Marcy said, once it happens, it becomes a difficult process to correct, especially if you don't have the right attorney doing it for you.
You know, that's why these are real situations and real things that have happened. So that's why I was so curious about it. But I think I'm hearing when you're talking about going to the first question we asked you, get the right attorney. And it said, well, one of the things you should think about is the fact that you have a countrywide coverage, which is what your law firm does, right? So in my situation, I was in Pennsylvania. Mom took off one day. She's gone. She's in California. I've known people in California. They've gone the other way. They've gone 3,000 miles away and taken the child. But if you have the coverage, and most law firms are not that large, maybe there's from the very beginning, from the get-go, find one and a firm that can handle this, because even like you're saying, there's not that common. However, they're happening. So people need to be prepared for that. And then what do I do in this case, in this situation?
Yeah, I think predictability is the biggest thing. Even if you don't necessarily think it's going to happen, it's like an insurance policy. Having it in place, might very well be, the thing you wish you don't have to use, but you're glad you have it when you do.
And there's always red flags to look forward to. I mean, if you're concerned, if you have a parent that doesn't have any ties to a particular jurisdiction, they don't have a job there, they don't have a lot of friends, there's families from another state. Same thing if they're dual citizens, if they have citizenship in our country and another country. I mean, there's different, or if they've indicated before, I'm going to take the kids and never come back. There's certain red flags to look for that kind of can put yourself on guard if you're looking retrospect to move forward or to look forward, if that makes sense.
Yeah, people have a tendency to kind of bury their head in the sand sometimes, especially in periods of heightened anxiety or heightened stress, that they just want to say, you know what, it's not going to happen. Forget, all that stuff that, after the fact we say, oh, well, we should have known, they're never going to do it. We hear it a lot of times, they're never going to do it. They forget that, they have dual citizenship to a non-Hague country. They're here and they know that that'll hurt our kids. Well, that's not to say 6 months from now they won't have a different opinion of that. And if we're allowing travel to non-Hague countries, then you're really taking that risk without any sort of recourse or insurance policy.
This is where you need the therapist and the counseling to begin with. Marry the right partner. So what most of us think, of course, is it's not going to happen to me. It's going to happen to somebody else. But what you're saying is, yes, you need to be aware of these things probably pre-entering the relationship or a marriage and knowing those things. But that's where the therapist and the counselor can help out. Get these things straightened out before you get engaged and before you get involved with that individual.
Hindsight's everybody's 2020, right?
Yeah,
that's right.
They all say it's absolutely the truth.
So I guess that kind of leads to my next question, which I know isn't the one on the list, so I'm going a little off here, but I'm just curious, what do you guys see as far as divorce percentages of high conflict? Obviously, what we're talking about here is very high conflict divorce. So what is the percentage you see of that versus an easy resolution divorce, or maybe even elaborate on one that you think's going to start easy and then turns high conflict? And you can ballpark the numbers percentage, obviously. But
well, we might not be the best two people to ask because most of the cases we get are high conflict.
Okay.
If, that's just our positions at the firm. But if I step out, I would say that the majority of cases still settle. I would say that the majority of, people want to work together. They want to be able to co-parent. They want to move forward successfully with their lives. I would say that is still the majority. But, there is, because of the way, our roles in the firm, I get a lot of, what I mean? Mine tend to be high conflict custody cases, high conflict litigation. But and in regards to, and yes, there are those situations where people are like, oh, we're going to do a dissolution. They want to reach an agreement and then just something explodes, right? Or, something, nor, there's just some little point that they just can't agree on, whether it's they get stuck on who's residential parent for school purposes, or the parenting time schedule, or, normally it's just some fundamental point that that they can't reach terms on. And sometimes it's emotional based, and it's always going to be emotional based with kids in custody situation, because that's your kids, right? Before you filed for divorce, you got to see them every day of your life, and now you're looking at a situation where maybe you only get to see them 50% of the time, or maybe you're looking at a situation where the other party is saying no, but you can only see them every other weekend. Those are things that are, if you're a dedicated parent, those are things we're fighting for, right? Is your time with your kids. So those are the things, in my opinion, that can move from what you thought was going to be a nice, easy, we're going to agree to everything, to, oh, no, we're not. It kind of goes out the window.
Okay.
Yeah, I think the evolution, at least as I've seen it in the last decade or so, is, you could probably, 10 years ago, compartmentalize, 99% of cases into, like 4 quarters. There was the quarter that was always going to settle. They were just going to resolve everything. There was that quarter that was always going to fight about everything and never going to settle anything. And then in the middle, there were those ones, I call them flash in the pans, where they start off hot. They think they want to fight, that first initial battle. They're like, no, I want to settle. And the other quarter was, I really want to settle. Oh, wait, that's what they're going to get. No, now I want to fight about it. Now we're seeing almost a move toward the poles, as might even be the norm in society at this point. Is we're seeing very little of that middle. Like if they're fighters, they're going to be fighters, and if they're settlers, they're going to be settlers. And there's very few in the middle that feel as if they can move back and forth within that process. Now, some of that is obviously due to the backlogs and the struggles to get into court and that sort of thing, that they almost feel like they have to fight about everything because they already got a court date and they might not get another one. But we're really seeing that the high conflict cases go up in number and up in severity, but also this shift toward a larger amount of people just wanting to settle things and kind of take control of their own cases, mediate, collaborate, do alternative dispute resolutions. And I mean, sometimes to their own benefit, sometimes to a fault. They have subscribed to that idea. And I think it's, it's more than that, maybe 25% on each poll now. It might be 40% on each.
Good observation. Thanks for sharing.
Yeah, I have just interject. I just say, just in relationships in general, to me, it's the, where do you, where do you squeeze the toothpaste, right? Anything you thought was cute at the beginning, you squeeze the toothpaste from the middle of the tube. That drives me crazy. So all those little cutesy things at the beginning turn out to be not so cute. And then you start fighting over really, really petty things. And that's why it potentially can blow up.
Yeah. One of my things that I say probably weekly to my clients is you got to focus on the forest through the trees, right? You need to pay attention to the big picture, right? This little weed over here, this little weed over here isn't going to really impact the whole forest. All right. Always keep your eye and your focus on the entire forest, because all these other little things are going to hold you back. So I try to, I say that, like, I don't want to say preach it, but that's probably what it sounds like. It's like, you gotta maintain your focus, make sure that you're looking at the big picture. In 10 years, is this going to matter?
True. So I think that leads into our next question. So when court orders are broken, not followed, how do you go about enforcing those?
I think every state's got their mechanism for it. It's just a matter of being able to navigate it. The law is the law, and I think one of the biggest questions that we always get, well, how can I make her do this, or how can I make him do that? Well, I mean, the short answer is you can't, but you can legislate into your orders the consequences for doing so. There's laws out there that say you're not allowed to murder people, but that doesn't stop people from murdering people. It's the same way as you have in a court order. You need to make sure that there's appropriate punishments, and that not only are you holding the other side accountable for those punishments, but you're holding the court accountable for enforcing those punishments. So you want to, play defense through offense like we talked about before, and have appropriate remedial measures put into your court orders, so you can almost, for lack of a better word, force the court's hand into doling out the appropriate punishment, maybe when they're more apt to give a warning or a slap on the wrist, or say don't do it again as part of it, because the order is only as good as the enforceability of it. And when you have one side that doesn't want to abide by it and feels as if there's no consequences for failing to abide by it, then it's not worth anything to you.
Typically in Ohio, the remedial ways to enforce a court order is via a motion for contempt or a motion to enforce. Consequences vary depending on whether or not which one you're filing, the motion to enforce or motion for contempt. If somebody's found in contempt, the court can order prison time. They can order reimbursement of attorney's fees, but they always go back to is how do we get the movement, the filing person, how do we make them whole? That's what they're looking for. How do we make that whole? So if a person has been denied parenting time, they might order that parenting time be made up, and that it be made up by a date certain. Often courts, depending on the county that you're in, because every county operates a little differently, but if it's a contempt action and a party's found in contempt, they're going to issue a purge hearing. So they'll give them so much time to essentially purge the contempt, make the other person whole. I think it's important when your attorney is writing a decree or writing an order that they make sure that they're using clear language, nothing vague. You don't want anything that's open to interpretation. You don't want a party to be able to say, well, that's not what I meant. That's not what I thought that particular provision meant. It needs to be as black and white as possible with very little gray, so that there isn't that argument that, that's not exactly what happened. That's not exactly what this provision means. It is, the more black and white it is, the more enforceable it's going to be.
So I have a couple of follow-up questions to that. Rick, in regards to the timing, and you can probably both answer that because Rick in PA is probably a little different than Marcy in Ohio, but are contempts heard a little faster? Or, if you filed to enforce, are they heard a little faster, or are they drug out during that time? And then there's just more and more of them that build up. So if they violate parenting time for a week and it's not heard for 3 months, and they keep denying time, does that build up, I guess? Or what does that look like?
So yes and no. And I think it's important to draw the distinction between contempt and enforcement. So if that situation were happening to one of my clients and somebody was wrongfully withholding custody, I would do a petition for contempt, which would be the punishment and the moving forward portion of things. And then I do a petition for enforcement to say whatever the reason why my client was denied that time is not a valid reason, and I need a judicial determination that it's not a valid reason. So we don't get 3 months down the line at a contempt hearing and have the other side say, well, I thought it meant this, or I was reasonable, or it was ambiguous, like Marcy had said, and that the language wasn't clear enough to tell me exactly how I was supposed to do this or when I was allowed to do this other thing. So from the enforcement standpoint, those are typically pretty quick. It's usually a motions court schedule. Some courts in some counties have it, every judge is hearing them every week. Other courts have maybe 2 or 3 times a month that, your assigned judge might hear it. So odds are you're getting in within a week or two, and there's going to be some do this pending this contempt hearing, and then we'll find out what your punishment, if any, is a couple months down the line when we can squeeze you in for a contempt hearing.
Yeah, I would say our process is a little bit slower. You're not going to get in front of a court, at least in the area of Ohio that I practice in, within 2 weeks of filing. Sorry. Oh, sorry. Allergies. Okay. But you're probably looking at, and sometimes they're going to schedule a pretrial hearing before you're actually going to have a contested hearing on it. So you're probably looking at 3 to 6 months for a contempt action or a motion to enforce. And honestly, a lot of times it depends on the court's docket and the court's availability and who your assigned magistrate or judge, what their calendar looks like when they can put something in. I will say during COVID, everything got pushed back significantly. Every hearing got pushed back. Every, motion for temporary custody or contempt, everything got pushed back. Everything is getting a little bit, more back to normal now as far as the regular time periods that we go, but they are still going to take, time because again, a lot of it's based on the court's docket and, attorneys availability if both parties have counsel.
And I think that raises another interesting point, Mars, that you need to do whatever is in your power and still within the bounds of the law to be able to remediate and mitigate the damages caused by another party's contempt. If it's contempt because they didn't show up to a middle point custody exchange, I'm going to tell my client, go to their house and pick the kid up as long as they're allowed at their house. Don't cause a scene, but make sure that you're doing efforts that aren't running into court in order to remediate that situation. If the solution was that you go and pick the kid up at the other side's house, the judge isn't going to be particularly keen on you bringing a custody contempt and occupying an hour of the court's time, even though the other side was wrong in not bringing them to the custody exchange when you could have just driven a few miles and got the kid. So you have to take those reasonable self-help measures, so long as they're bound by the law too, to be able to minimize the damage and not continue to backlog the courts with it.
Mm-hmm.
That makes sense. And I think in certain cases, you can go pick up the kids. In other cases where the kids are scared or been told that they're not going with the other parent and they refuse to go, an officer can be called to the scene, but an officer cannot force the child to go with the parent. So you still have a contempt and you are still losing that time with the child, and the psychological damage is still happening. Yeah. So that's just kind of the other side of it too.
And then those situations, I think that, try to get it in writing, right? So if you don't communicate well with the opposing party, send them a text, hey, I'm here, where are you? And they say, we're not coming, so doesn't want to come. And I'm like, well, you're the parent, and but you do it and, you can say, okay, so what I'm hearing is you're not going to bring Jane for my parenting time. Is that accurate? And then you've documented it. And then if you wanted to take it a step further, you could even file just a police report. You don't have to have the police there, but just, have it documented so that when you go to court and you do file that contempt action, you can say, this is the communication I received. I didn't have to take that extra step of going and making a scene with my kids with the police officer there, but, they acknowledge that they're denying me time.
Yep.
Still going to provide you the evidence that hopefully that you would need to succeed in a contempt action.
And Marcy, I think you bring up a really good point is people need to document, not a phone call. I know that's usually the way that people used to go, right? But document it. Text, email, use your state provided court ordered platform. Ours is the Wizard, right? The Family Wizard. Every state's different, but they have some kind of platform you can communicate on. The judges can view along with the guardian ad litems and attorneys at that point. And so I think that's a big point. You need to document. Hopefully what happened to me doesn't happen to everybody, but my contempts got pushed off the judge wanted to hear them in the final hearing of the custody evaluation. So the contempts never really got addressed. So it just kept going for probably about 1.5 years.
Yeah. And that does happen where they kind of put everything to hold it all together at the end. And maybe it's a time saving measure. Maybe it's, more economically efficient, whatever the circumstances are, but that's not an uncommon occurrence to put all the actions together if you're in the middle of a custody action and a contempt action and hold them all at the same time.
Yeah. Rick, were you going to say something?
Yeah. I just think that too becomes part of that enforcement mechanism. When you talk to the police and you have a report that just says, listen, I was here, I responded, the dad or mom is reporting that the kid won't get in the car, but mom or dad is here to pick them up, by my, policy, within my department, I can't act on it. Now we have something in writing to say this is a new enforcement mechanism that we can take to the judge to say local law enforcement may intervene to allow for that. So it kind of overrides whatever that policy is. Also, I think doubling back to the attorney understanding the problem, understanding the process, understanding the the judicial backlog is getting the idea of the prejudice that was caused in your case in front of the judge at month 1 instead of month 18, could have really served a huge role in making sure there were additional enforcement measures, even if the final contempt and whatever punitive measures didn't happen for 18 months. You at least have an enforcement measure in place that would have prevented that much more prejudice, that much more damage to the kids, that much less of that argument of, well, forget why we're here. The fact is we're here, and now the kids don't want to have a relationship with this party, or they're estranged from this party, or this party needs to jump through more hoops to get it. So I think you have to be proactive in doing that. I think part of that is having the attorney that understands, what's going on and kind of where that cog fits into the machine.
Yeah, good point. I have a question for both of you, and it's probably, I'm going to guess it's a state-based, but I don't know. I believe the Supreme Court has some type of, they oversee all these cases, right? So at some point, the divorce has to be done at a certain time frame, or something needs to happen. Can you guys explain that situation and what happens there? Like, for example, a divorce can't go on 3 years, or it can't go on, whatever that stipulation is.
So the Ohio Supreme Court issues guidelines. They're not necessarily statutorily enforced, but they're guidelines. For instance, like a divorce with children should be completed within 18 months of filing. A divorce without children should be completed in 12 months of, I believe it's 12 months of filing. A post-decree modification should be completed within a certain amount of time. But they're guidelines. They're strongly, suggested, and the courts try to enforce them, and they kind of, do their checks and balances and look at the time periods and making sure that they're abiding by those guidelines, but they are guidelines. And there are circumstances that I would say they're a little rare when they can't, for whatever reason, abide by those guidelines. But I would say those are more anomalies. Somebody having an illness, or an attorney getting, some rare occurrence. But I would say that the majority of the time, the courts that I work in do abide by those guidelines.
I think that's good for people to know.
Yeah, Pennsylvania is just completely different, and I get this a lot, and Marcy makes fun of me for living here. And
I know, I'm kind of starting to agree with her at this point, right?
Ours, we don't have a set time frame. There's no dictation as to when it needs to be done by. In fact, up until a few years ago, there was actually a dictation that provided for prolonging divorce matters, in that one side couldn't force the other side to participate in a litigation until they had been separated for 2 years. So the court finally came down a handful of years ago and said, well, we're reducing that to 1 year. So if I filed a divorce action on behalf of my client today, and the other side just didn't want to participate, then they wouldn't have to until February 14th of 2024, at which point then I would be able to compel them to start participating. I can compel them to meet deadlines for filing and that sort of thing in the meantime, but we can't actually get our hearing dates scheduled, get in front of judges, hearing officers, that sort of thing, until February 14th of 2024, which means most with the backlog now that fall within that section of the rules aren't getting done for 2 or 3 years, and that's almost by the court's own doing.
It makes me feel like we fast track things.
No kidding. Jeez, Rick, you have a challenge there.
Move to Ohio. I think that's the message. Right? Out of Pennsylvania. Is that what I'm hearing?
We still have a mandatory.
I feel like it here, but compared to Pennsylvania, apparently we move a lot quicker.
So we have a rule here in Pennsylvania that even if everybody were sitting at my desk saying we have no assets, no children, we made a mistake in getting married, and we don't hate each other and just want to be done with it, we still couldn't get you a divorce decree for 90 days.
It's crazy. Well, Mick, do we have any final questions?
Well, I had a couple.
Rick?
Just a couple things came to mind. Just if both of you could address the question, a person is thinking about going and entering this process, they're in this process, or things have not gone well. what kinds of advice, strategies, or ideas would you suggest to potential clients, and what could you recommend that they do or think about as they enter into this process, or they get involved in, or they're already involved? What should they do? I think that's what a lot of people are asking. I don't know what to do. So what would you recommend?
I always want, when I first meet with a client, we go over their goals. Tell me the things that are the three things that are most important to you. Okay. And moving forward. And where do you see your life in 5 years? Okay. And those are the things that I, kind of help remind them of as we move forward. All right. To focus on those goals and to kind of, keep that in the back of their mind, because really what we're trying to do is help you move forward. We're trying to be able to help you get to that next point of your life, because once your divorce is over, your attorney's gone. You have to move on. You have to, abide by these court orders. You have to be able to, care for yourself and your children in whatever manner. So if you can kind of focus down and narrow down what those ultimate goals are, in my opinion, that helps you move through the process, because you're prioritizing, you're understanding and self-awareness what is important to you.
I think I divide it into two different sections. If you're kind of going at it alone, or you're at the early phases of things, or you're kind of under that impression of I can do this myself. By the time you think you probably need an attorney, you've already needed an attorney. Even if it's just to consult with one, even if it's just to understand one. I think too many people get caught up in the idea that the law is always fair and the law is always true, when that's only if it's applied appropriately and legislated appropriately. It's just not always the case. So folks agree to things that seem okay on their face, equal custody, equal division of assets, paying alimony for some period of time. We get ones all the time that are, quote unquote, waivers of child support. Well, what you don't realize is the law doesn't allow for that sort of thing. And if you gave up your entire pension in exchange for never having to pay child support, you gave up your entire pension, and now you have to pay child support. And these are things that if you don't know the law, you don't necessarily know. Or if you assume the best in the law, you might get caught up in or taken advantage of. So consult with someone. You don't necessarily need to hire someone right away, but you really got to understand things and get comfortable with that process, because if you already have things scheduled, or you've already signed papers, or you've already taken actions on your own behalf, you may have already done some irreparable harm to your case that you haven't necessarily understood. Now, the folks that already have attorneys and it's just kind of stagnating, or they're not getting what they thought they were supposed to be getting, and that sort of thing, I think that goes back to what Marcy had said earlier on in the case, or in the show, was you got to get that feeling. You got to get that feeling that even if things aren't great, that they're going okay, or that this person has my back, or this is something that, even though it's a bad situation, it's going as well as possible. If you're not getting that warm, fuzzy feeling, go talk to somebody else. Go get a second opinion. I've had plenty of clients in history that have gone to get second opinions and came back and said, okay, Rick, I didn't trust you before, but now, 3 other attorneys have told me the same thing. And now we're on the same page. If nothing else, that's helped my attorney-client relationship with those folks, because there's not that level of skepticism in things. You're not going to hurt my feelings by going and getting a second opinion on things, but sometimes you almost have to see that, the grass isn't greener on the other side, or there isn't, some pot of gold at the end of the rainbow. And that'll help you manage and make decisions in your litigation, to your betterment during that process. So I think communication is key on both fronts.
Thanks for that. Kendra, I don't know if you have any other questions, but before we go, because I know we're winding down, I wanted to ask Marcy, because we've been talking about legislation, and Ohio does have legislation currently. So I'm wondering if you could just add your thoughts on the current Ohio legislation that is up this year, I guess, for a vote, correct? Or going to be.
HB 508.
Yeah. Well, yes, it'll get a new House bill number here shortly, but yes.
So making sure we're talking about the same one.
Yes.
I'm a huge fan of this particular legislation because if it is passed, it will go to default shared parenting, similar to what Kentucky does. And it would be a default 50-50 parenting time schedule, which is also similar to what Kentucky does. I always have I'm trying to frame it, in an appropriate manner. I get concerned sometimes that when, a party files for divorce and the first thing that happens is that a court issues temporary orders regarding parenting time or a temporary order regarding custody. And now that person who has been on the equal footing with their spouse for however long has now just essentially lost half of their parental rights as soon as they walked in the door. Before there's been a full custody case, before there's been any, guardian ad litem investigation or anything else, it's just, it's just gone as soon as they file paper. And I think with the adoption of this kind of legislation, I think that it would actually assist in lowering, because it's the default, right? This is what the court's automatic go-to was. And it would essentially, if I understand the statute in the way that the proposed legislation is written correctly, that it has to be huge. It almost has to be a detriment to the child for it not to be shared parenting, meaning there has to be some kind of physical abuse, drug abuse. Like it's not like, oh, I can't get along with him or her, whatever the circumstances are, because there's married people that don't agree on everything and have different ideologies on how to raise their kids. But they don't, it's just applied so much more fairly. And honestly, I personally believe that it's in the best interest of the kids to have that continued diversity amongst their own parents, because there is no one perfect way to raise a kid. So, you might have diversity in opinions as divorced parents, but the children actually receive the benefit of those two different opinions a lot of the time anyway. But anyway, sorry, I digress. But it would automatically be shared parenting default, and it would default to 50-50 parenting time. And I do think that it would limit or lower the amount of contested or highly litigious custody cases, because it would be a much more difficult standard to achieve. And if everybody kind of got on board with that, this is the way that it is, I do think that it would limit the litigious custody cases in Ohio, personally.
Yeah, thank you.
Well, thank you for your feedback, and thank you for supporting it.
I'm a big fan. I think that it should be passed.
Thank you.
Oh, you have any other questions, Kendra?
I don't. We have had a wonderful time with both of
Fantastic.
you and learned a lot. So thank you very much for taking time out to speak with us.
Thanks for having me.
Thank you, both Rick and Marcy. It's been phenomenal. Learned a lot. We really appreciate your time and taking some time out of your busy schedule, because we learned a lot, and this is what really people are listening for, and this is what they want, is some help. So we got some really good advice. So I really appreciate your time. Thank you very much for joining us today.
Anytime.
All right, we'll go into the green room, and then Kendra and I will wrap things up. Well, that was quite a session, was it not, Kendra?
Yes, it was. It was very informative.
I'll tell you, all the questions that we want to ask, and love to have them back or learn out more. But for the time being, what we want to talk about here to kind of close out the show too, we had talked about trying to get some sponsorships, because as the podcast has grown, we're looking for sponsors. So we'd like to run Facebook ads. We have a magazine promo potential, YouTube promos. As it's grown, we also have administrative tasks that have also grown as well. So we'd like to try to look to see if we can get some support for the podcast and all the good things. And if you know people, get in touch with us, because we have some needs now. Things have gone well, and that's good. So, and if you want to get a hold of us, of course, contact us at theaftermathhealing@gmail.com. And if you do have other ideas, suggestions, or potential guests, let us know that as well. Listen, like, subscribe, share, and positively review. And of course, you can get the download. What was the download called now, Kendra? What was that all about?
Oh, I think actually we're offering some free advice.
Okay.
In a book. So people have to check it out. They'll have to email us to get that.
And one of us is a jailbird and one of us is a juvenile delinquent. Now, which one is which? So get that download. But thanks for joining us today on the Aftermath podcast. Please stay with us until the next exciting episode. Until then, Deus Volt.